If you call me over, you're my next door neighbor, you call me over and say, I'm not a doctor, I'm just a next door neighbor. You call me over and say, I haven't been feeling very well for a couple of days and I got this rash and I've had a headache, and you go through a few symptoms and you say, well, what do you think? Should I go to the doctor? I look at you and I say, well, you don't look that bad. Take a couple aspirin and, wait a couple of days, and if you're still feeling bad at the end of the week, go to the doctor. So you're still feeling bad at the end of the week, you go to the doctor, you got some horrible disease, and the doctor says, if you had only been here 3 days earlier and hadn't listened to that neighbor of yours, you would have been okay. Now, so tell me now, given the fact that the sovereign immunity statute says that to the extent that sovereign immunity is waived, it's only waived to the same extent that a private person would be held liable for the same conduct. So now am I, your neighbor, responsible because I gave you bad advice and caused you to delay treatment?
Excuse me for interrupting. No, Your Honor. The neighbor would not be liable under that scenario, and neither would a law enforcement officer be liable under that scenario. The restatement second talks about coming to the aid of someone who's helpless to assist themselves. When a neighbor asks for medical advice from a neighbor, they have the capacity to make their own judgment about whether or not to seek medical care. In this case, Mrs. Wallace did not have the opportunity to seek her own medical care, while the sheriff's office had no duty to go and check on her, to take care of her, to assist by performing a well-being check. They assumed a duty to use reasonable care. This case is similar to the case Hartley v. Floyd. There, the sheriff had no duty to check on a man whose boat was missing, who hadn't come home from a fishing trip. But the sheriff agreed to do that. The sheriff undertook that duty and then performed it negligently. And as a result of his voluntarily assuming that duty, the duty arose and there was liability for the failure to use reasonable care then in fulfilling that duty.
Just to follow up on Judge Orfinger's question, using your analysis, wouldn't the Genders be liable as well?
Your Honor, that's not an issue before the court today. I haven't examined whether you're talking about the next door neighbor.
You were willing to answer his hypothetical.
I honestly don't know.
Answer my hypothetical. Why wouldn't the Genders? I mean, his question is, if sovereign immunity is waived only to the extent it would be waived as to a private individual, and we've got two private folks standing on one side or the other of this deputy, why aren't
I have no doubt that question will be presented to the jury, Your Honor, and the jury, assuming that this case makes it to a jury, will be asked to decide about negligence on the law enforcement officers or the neighbor. But the issue...
Let me ask you this about the helpless individual. If someone, not a police officer, is walking down the street and sees a 2-year-old in a bad position of some sort, injured, does that person walking by have a duty to help the 2-year-old?
No, Your Honor. Under Florida law, clearly there's no duty to be a rescuer. There's no duty to come to the aid of someone in need. There is a duty once you voluntarily come to the aid of someone in need that you perform that undertaking with reasonable, ordinary care. And the question of whether these deputies used reasonable, ordinary care in this situation is a question for the jury to decide.
Well, they did undertake to allow the neighbor to enter the house.
Yes, sir.
All right. So if anyone was injured because they entered the house in a way that was unreasonable, they would be liable because they chose to enter the house. But did they choose, as alleged in the complaint, did they choose to render medical care?
They certainly elected to render medical opinions at that point to the neighbor. The deputies elected to render a medical opinion about whether or not this woman was in a diabetic coma. The deputies also elected to go in and perform a well-being check. If there's no duty to use reasonable care when performing a well-being check, this woman, and probably many people, would be better off for the deputies to simply stay home. let the neighbors talk to the daughter and find out a way to get into the house and do their own check, rather than have the deputies come and affirmatively represent something that in fact was not true.
Well, the case with the boat, with the husband who went out on the boat, the police officer went and then called and said there is no car here. And therefore the wife assumed, well, he didn't go boating today because the car's not there. Now, that's a factual representation on which the wife relied upon in not seeking help elsewhere. What happened here, where there's a misrepresentation, not a bad opinion, but a misrepresentation, which would induce one to not act?
There was a statement of fact. A person in a diabetic coma would not be snoring. Statement of fact given by the deputy to the people who were there trying to see about what to do for this woman, Mrs. Wallace. There was reliance on that statement of fact, and that is one way, reliance is one way that a duty arises. It's not the only way. Even had they not said anything, even had there been no statement of fact here that the neighbors relied upon, the duty arose as soon as they undertook to come to the aid, if you will, of this woman. That's the undertaker's doctrine that the Florida Supreme Court talks about in Kropf. The third DCA says, it is well settled that an action undertaken, even gratuitously, must be performed in accordance with an obligation to provide reasonable care. In Horton v. Freeman, the 4th District Court of Appeal, same thing. There must be reasonable care. Thank you, Your Honor. I see I have 4 minutes. I'll save that for my rebuttal time.
I'm going to ask you one question, but I'll give you an extra minute. I'll just stop the clock, so I'll still give you your 4 minutes. How's that? And I'll give you an extra minute.
Thank you, Your Honor.
But just to come back to Judge Griffin's hypothetical, if the police had never gotten involved here, and Mrs. Wallace calls Mrs. I think it's Ginder, the next door neighbor, and says, you know, I haven't been able to get hold of Mom for a couple of days, go check on her. And she does. She's able to get in the house. She's got a key, whatever. And she looks at Mom, and let's say she does exactly the same thing that the police did here. Exactly the same. I think she's just asleep, and she looks fine to me. Calls back and reports that. And everything happens as it happened in this case, except that the law enforcement wasn't involved. Mrs. Ginder, under your scenario, then, is on the hook, right?
Mrs. Ginder assumed a duty when she voluntarily agreed to go and check on the neighbor. In many cases, whether it's a private actor or a governmental actor, voluntarily undertaking that does give rise to the duty. We get Union Park Memorial Chapel, Florida Supreme Court case 96, where funeral director voluntarily decides to organize the way the procession's going to go, and he assumes a duty by doing that.
Okay, thanks. Thank you very much. All right. Good morning.
Good morning. My name is Bruce Bogan, and I represent the Sheriff of Marion County. The Sheriff of Marion County believes the trial court correctly determined in this case that no common law duty of care was owed to the decedent.
I think that we're all in agreement, including appellant, that there's no statutory or common law duty. The question is, and I think that appellant's counsel is focused on their theory, which is once you voluntarily undertook to go check on her well-being, did a duty arise then to exercise reasonable care? Now, I agree that, you know, I'm sure if it ever gets to that point, you would say, well, we did exercise reasonable care, but the question is, do they get through the courthouse door? So under their undertaking theory, how do you respond to their argument, in the restatement that says if you take charge of another person who's helpless, you've got to do so with, reasonable care?
Well, first of all, I think that the undertaker doctrine, except for that Torres decision, which she cited from Chicago, has never been applied in Florida to a situation involving a law enforcement officer responding to any type of a situation. And I think that law enforcement officers are in the unique set of circumstances that should be considered differently than an individual who is simply a citizen.
But doesn't the sovereign immunity statute say just the opposite? Doesn't the sovereign immunity statute say that you'll be held to the extent that sovereign immunity has been waived, that you'll be held liable in exactly the same way as a private citizen?
Under certain circumstances, that is true, except for in cases where law enforcement officers are performing discretionary functions, and they still have immunity as it relates to those type of special circumstances under sovereign immunity principles. However, the courts have, in cases, carved out situations where a special relationship has been established by virtue of the actions taken by law enforcement at the scene of traffic stops or in responding to various different law enforcement responsibilities.
Let me ask you this. Let's leave out the neighbors here. If the daughter calls from out of state and calls directly to the police department or the sheriff's department and says, my mom is elderly, she's not answering the phone, could you go check on her residence, which is such and such? Now, the sheriff can say, no, ma'am, we don't do that. No liability, correct?
Correct.
Okay, if something bad happens to her in the
Not until possibly election time.
That's
okay.
a political decision.
But instead, the sheriff's department says, that's fine, ma'am, we will send out a deputy right now to check on her. And the deputy goes in there, goes in the house, and doesn't exercise reasonable care. Sees that she's clearly in need of medical care, but doesn't do anything, and then calls the daughter back and says, your mom's fine. Now, are we now then in the Hartley versus Floyd situation?
Well, I think you're getting closer to the Hartley versus Floyd case under those scenario, because obviously Hartley talked about the situation where the wife calls directly to law enforcement and asks them to do a specific check at the boat ramp. They go to the boat ramp allegedly, but they really didn't do that in the case. And then they made a misrepresentation to her over the phone and said, in fact, we checked the boat ramp and your husband's truck and trailer are gone. And based on that, she delayed reporting to the Coast Guard for 8 hours the fact that her husband was missing. So
all right, we're going back to my hypothetical. If they call the daughter and say, we went out there, and they didn't, would you say they're liable? If they didn't even go check her?
I don't know if you say they're liable. I mean,
is there a cause of action against them because they undertook
if they made
that?
some direct representation to the Wallace family, similar to what Hartley occurred in the Hartley case, then I think you have a closer situation where they may have had a duty. But we made no representations in this case to the Wallace family. There was never any communication whatsoever to the Wallace family between the Marion County Sheriff's Office and them. Ms. Wallace never called us.
Does it matter who the communication is with?
Well, that's a good question. And the plaintiffs in this case amended their complaint to try and make an agency relationship. In fact, that was part of one of their issues. If you noted, the trial court determined that there was no agency principles or a relationship in this case between the Ginder family and the Wallace family, and rejected that theory. So,
well, I got to tell you kind of up front that I think that's a bad call. I think that from a pleading standpoint, the pleading would indicate that the Wallace family, in essence, deputized, to use that word, the neighbor, to sort of act as the surrogate to go check on mom. And so, I mean, I think that's enough, at least from a pleading standpoint. I'm really more focused on the issue of discretionary. What discretionary, when we talk about discretion in this case, are we talking about the discretion to make the decision that, yes, I have no duty to go out and make a well-being check. I, sheriff, have no duty. But I'm going to exercise my discretion to do so. Is that a discretionary call?
I think that's a discretionary call,
okay.
Yes.
So now, having exercised the discretion, once I get there and I see and let's assume, again, just to make the hypothetical easy, let's assume that any reasonable person would have found mom to be in a desperate situation. You know, she's bleeding profusely and all sorts of bad things are happening. Is it your contention that having exercised the discretion to go make the well-being check, that what happens at that point, in other words, presumably you've got two, well, maybe more, but at least two choices: do nothing or call the ambulance and EMS. So is it your contention that having undertaken the discretionary call to make the well-being check, that what you do then, having undertaken that duty to make that check, is also discretionary?
Yes.
So your contention is that the discretion, it's not an operational function now that I'm there, well, you know, I need to call the ambulance or not. That's purely discretion in the same sense as I'm going to arrest this fellow or I'm not going to arrest this fellow.
Right. And I think that goes along the line of with the cases such as Brown versus Pinellas Park, as well as cases which talk about placing you in the zone of danger or worsening their situation by the actions you take. In other words, your immunity, decision-making, the decision of whether or not to chase that car, that's still protected under the public duty doctrine. And when you engage in that pursuit, if you...
Well, but again, those cases go off in a completely different direction in that, they talk about that there's a duty owed to the general public and not to individuals that are specifically harmed absent a special relationship.
Right.
So we come right back then to the question is, was there a special relationship and did you undertake the duty? And again, that comes back, I guess my question then comes back to your contention is that I think I agree with you that it's purely within the sheriff's discretion whether he chooses to make a well-being check or not. He could have said no and had no liability, but having done so, does the sheriff then have some duty to do that with reasonable care?
If the special relationship was established according to the law, and in this case, we don't believe that a special relationship was established just merely by responding to the scene and making an observation of an individual and determining that they were asleep. We left her in the exact same position as we found her. We didn't worsen her situation. We didn't make it better, obviously.
I agree on the zone of risk analysis. You didn't do anything that, you didn't place her in the zone of risk. You didn't do anything like that. I agree. This, in my mind, this really comes down to the question of, under the restatement and the cases that talk a little bit about the restatement. Having walked in there and being in the best position to do so, did you have some obligation to make a more accurate assessment if their allegations are true? We all recognize that that's an open question.
Right. Well, and I think I agree with you that once we arrived at the scene, that there's decision making that has to be made. I mean, and the officers have to be given, under sovereign immunity principles, some discretion as to how they're going to respond there and what they're going to do. If they place her in a worse position, if they put her in the zone of danger by their actions, then according to the case law, they don't have sovereign immunity for those decisions that they made. But if they make a decision that doesn't put her in a zone of danger, or if they make a decision that leaves her essentially exactly where she was before, or didn't make her better, then I think they're still protected, and that's what our position has been here.
What concerns me about the case from a policy perspective is that if I'm the sheriff of Marion County or whatever county, I'm going to be confronted with one of two possibilities. I think, as a practical matter, it's almost impossible to say, no, we won't go check on Mama. So they're going to be forced to go check on Mama. And unless Mama is out there doing calisthenics, they're going to call EMS every single time. And it seems to me that the potential for, completely overloading EMS, that no reasonable law enforcement officer is going to want to undertake the idea that he might assess someone and make that error.
I agree, and that's one of the things that the trial court was concerned about in this case, and it's reflected in the order that the decision to hold them or to hold a common law duty, or that a duty of care exists in this case, will place a chilling effect on how law enforcement chooses to operate in the future in responding to a well-being check, which it clearly is not something that they have a duty to perform. And obviously there are political considerations as to whether or not you want to just take the position that when someone calls, says, "Can you go from out of state," and says, "Can you go check on my elderly grandmother?" Say, "Sorry, we don't do that." But that certainly would be one of the options. And as you pointed out, from now on, they may have to have a policy that when you send a well-being check, we also send, a fire truck and an ambulance. So, and it may not be necessary, and you're tying up services that, could be, necessary for other calls and other duties. So, yes, that is a concern, and the courts have obviously the right to determine whether or not, and take into consideration, I should say, public policy considerations in deciding whether a duty of care exists, and should a duty of care exist under any given set of circumstances.
Well, what about the argument that in a sense, they really did put this woman in a worse position here because she referred to it as a medical opinion. I don't think it's a medical opinion, but it is a trained person's opinion that the woman was okay, that she was just sleeping. If they'd gone and made the well-being check and said to themselves, and hadn't said anything else to anybody else, then the neighbors might have acted on their instincts and done something for her. But what happened here was that the reason the neighbors did nothing was because they had a trained person who essentially put them off.
Well, I think there's a couple of ways to look at that. Well, first of all, I respectfully disagree that saying someone is asleep is a medical opinion, and there isn't any allegation.
Right, but it is an opinion of a trained person. I mean, and the opinion was, she couldn't be snoring and be in a diabetic coma. If I'm just checking on my neighbor and I've got law enforcement there, and I've got this trained person in a uniform who says that's not a diabetic coma.
Well,
I am going to be far less likely to call 911 and tell them that I think this person might be in a diabetic coma.
Well, and I guess the other side of that coin is that the law enforcement officers didn't tell the Genders, or there's no allegation that the Genders were told they couldn't call 911 or that they should not call 911. What they told, and that's been alleged in the complaint, what they were told is that they're leaving a side door open so that they could come back in and check on her.
Doesn't that really address the question of causation or maybe comparative negligence on someone else's part? I think the focus here really is on the question of duty. Because if there's no duty, then it doesn't really make any difference what happens.
Correct.
If your argument, if it gets to trial, you can argue, well, Mrs. Gender could have called the ambulance just as well as we could have, or, she was just in as good a position to see this.
She could have come back much.
Or that we don't have any more medical training. We're policemen. We're not EMS people.
She could have come back 5 minutes later and called 911. She could have come, instead of waiting till the next
But those
morning.
are causation questions, not duty questions.
If they'd said, hey, I'm not doing anything. She looks to me like she's sleeping. I'm not doing anything. You do what you want to.
Well, and again, was she in a diabetic coma? That's really not alleged in this complaint.
Yeah, the proof problems here are going to be nightmarish, but that's not where we are.
It's not alleged anywhere that she was in a diabetic coma. All we know is that they're claiming 8 days later that she died, and that she died as a result of our negligence is what the allegation is. There's nothing in there that says what caused her to die.
Right.
So, you know, we could have left 5 minutes later. She could have, if she was sleeping, she could have got up and got a drink of water and laid back down and then had a heart attack. I don't know what happened to her, and it's not in this, not before the court as to what caused her to die. You know, I think in response to your question, the law enforcement officers made an assessment that someone is sleeping. I don't believe it's a medical assessment. I don't believe they rendered medical care, or they attempted to represent that they were medical EMTs or paramedics or what have you.
The jury might find that they were negligent at all. The question is whether you get that far.
It's whether, I'm sorry, whether you...
The question is whether you get that far, whether they can get to a jury.
As to whether or not they had a duty. And again, it's my position that they did not have a duty of care because the special relationship had not been established, and that the decision-making that they made there was protected under sovereign immunity principles. I'm not sure how else I can put it. I do not believe that the Undertaker doctrine, as I pointed out to you before, and the Clay Electric. Let me just mention briefly about Clay Electric. I know they've relied on that case very heavily, and the Clay Electric opinion does not address sovereign immunity. It does not address discretionary function, does not address any type of special relationship analysis involving law enforcement. We're talking about in Clay Electric, an electric company assigns, pursuant to contract, to this Clay Electric, a public utilities contracts with Clay Electric to maintain and change light bulbs. And they failed to do so. And because of that, the allegation was that a street was dark and unfortunately a child was injured and was killed in a car accident. And so, you know, clearly, factually, it's not even remotely similar to the type of situation that we're doing here. And also, there is language that they rely upon in the restatement of second that says you must have the actions that we have failed to do must have placed the person in a worse than their position. In other words, she had to be in a worse position as a result of what we failed to do. And again, I do not believe that we placed her in a worse position by what we failed to do. She was there, she was exactly how we found her, and we left her.
Mr. Bogan, is the decision, the deputies are in the house and they're looking at Mrs. Wallace. Is the decision to call or not call the ambulance at that point, from our analysis or the trial judges, is that a question of fact? When we talk about discretionary or operational, you know, is that a question of fact or a question of law, whether that decision at that point, they're standing there, they say we will call the ambulance or we won't? Is that a factual decision or a legal decision to conclude whether that's a discretionary or operational decision?
I believe that the decision as to whether or not sovereign immunity exists and whether the discretionary function application applies is a question of law for the court to decide, as well as whether or not there is a duty of care is a question of law for the court to decide.
All right, sir. Thank you so much.
Proctor, let me ask you, are the Ginders serving as agents for deceased daughter?
Yes, Your Honor, they are, and that allegation is in the complaint. It would be our position that the agency is irrelevant. The duty arose to Mrs. Wallace, to the person who was being checked. Doesn't matter where the call came from. Once they undertake to help Mrs. Wallace, they owe Mrs. Wallace a duty to use reasonable care. She's the one lying in the bed, comatose, that they cannot revive. Let me speak to sovereign immunity.
Let me then follow up.
Pardon?
If the daughter was in the house instead of the Ginders, and she sees the police officer on the street and says, "Come here, and I'm worried about my mom," and the police officer comes in, and they're both sitting there looking at the decedent now, and the daughter says, "I think I probably should call 911. She doesn't look right to me." And the police officer says, "Well, I think she looks fine." Does that change the situation? Because going back to, Judge Orfinger asked you the hypothetical about if he came over to your house and you're saying you don't feel well and you're thinking about going to the doctor and he says, I'd wait a few days, you said no liability. Well, what if the daughter's in the house and, it's really the same type of conversation?
Same duty arises if the sheriffs in that situation might say, the daughter's there's no reason for us to come and check on this woman.
No, but I'm saying the daughter's there and the police officer's there, and the daughter says, I kind of think she might be in a diabetic coma, and I should call 911, and then the police say, no, she looks fine to me, no reason to call 911.
Your Honor, the question of whether or not that was negligent, the officers would go to the jury. The question of duty would be the same analysis. Once the officers undertake to make a well-being check, they assume the duty to do so with reasonable care. On the second question, sovereign immunity, which we didn't get a chance to talk about initially, let me just point out that the Florida Supreme Court has defined a discretionary act as a policy-level act that involves fundamental questions of policy and planning, and an operational act as a secondary decision implementing policies or plans. Under that analysis set up by the Florida Supreme Court, the decision whether to go to the home, whether to go inside is discretionary. Once inside, it becomes operational. Just like a traffic stop, just like an arrest, the decision whether to do it, discretionary, shielded by sovereign immunity. Once the decision's made, the duty arises, it's operational, it's not shielded by sovereign immunity. The law officers have been held liable under the Undertaker's Doctrine in other cases. Incorrect statement that's never been applied to law enforcement officers in Florida. First National Bank, the city of Jacksonville. City officials undertook to investigate reports of child abuse. They did investigate. As a result of their investigation, others who knew about the situation refrained from doing anything, and the city officials were held to owe those children a duty of care. They undertook to investigate. They undertook to come to the aid of the children. Then they did so negligently. They didn't make those children worse off. They didn't hurt those children, but they left those children in the same situation they had been in before they got there. The duty of care still arose because they undertook to come to their aid, and they did not actually come to their aid. They left them worse off. The same is true in Henderson, where the Florida Supreme Court case, 1999, law officer stops a drunk driver, gets one drunk driver out from behind the wheel, tells another passenger, you get behind the wheel. They go off. The Florida Supreme Court said that those law enforcement officers were in an operational decision when they told that driver, that passenger, you get behind the wheel. Sovereign immunity didn't shield that. Not only that, but they had a duty to those passengers who were in that car. They're already riding with a drunk driver. They get another person behind the wheel who's also intoxicated, less intoxicated, in fact. But the Florida Supreme Court said there's still a duty there. Even though those passengers arguably no worse off, they were with a drunk driver before, now they're still with a drunk driver.
Thank you very much.
But the duty arose. I apologize for going over. Thank you, Your Honor.
Quite all right.